Okay, well, we're here on February, what, 3rd, 1988?
98.
98? Well, what's a decade, you know? So 1998, and what we're going to cover is a couple of things which I think are really important. One is how to represent yourself in court, because one of the biggest problems that people have in dealing with any agencies is normally the agencies just they don't deal with you. You know, they don't talk to you. They give you the runaround. The law makes certain provisions that they're supposed to accord you, and they don't do it. And so what you end up with is that these agencies have denied you your administrative due process rights and remedies. And because of that, you then have to go to court and ask the court to give you those things which you've been denied by these agencies. Which, by the way, when they do deny your administrative due process rights, that nullifies anything the agency has done. So if they have come in and assessed the tax against you or whatever else, when they refuse to give you that which the court or Supreme Court of this land says you're entitled to, because after all, agencies make mistakes, right? Or do they not ever make mistakes? They're constantly making mistakes. And because of that, the court says, well, you have certain remedies, and they have to accord you this right of a hearing, etc., and they don't do it. So because they don't do it, the court says, okay, well, these agencies which are consistently not doing this, if you just take them to court and show that they did not accord you that, and you ask for that, which you're entitled to, and they did not give you that, then we're just going to set aside everything they did. And that way, maybe, after they do it a couple of times, that'll stop the agencies from denying you that which you're entitled to. Of course, that was also the same reasoning for the Miranda warnings, where they would come in and say, okay, you have to tell people their rights, because they were constantly denying their rights because people were ignorant of their rights. You know, government controls education, and the government doesn't seem to want to educate people on how to defend themselves against them. I wonder why. So the Miranda rights were there to accord them some opportunities, especially the innocent people, what was going on when they were falsely accused. And then they have also the evidence when it's illegally obtained. There are right ways to do things, wrong ways, and sometimes the police facilities or government agency obtains evidence outside the way and means that they're supposed to do it. When they do, it becomes poisoned and not usable, okay, inadmissible evidence in court. And that also was being done all the time. And so they said, okay, you have to do it right. And so they said, if you don't do it right, we're not going to let you use the evidence, period. And so that's where that doctrine came from. Now, in order to bring this information forward, whatever it is we're talking about, since these government agencies are denying you this process, and since the courts have said your only remedy if the agencies won't work with you is to step into court, because the court is the area of final settlement. In other words, you're supposed to exhaust all your administrative remedies first before you go to court. They don't want you there before you've taken all the steps you can at the agency level, because otherwise the court would be overworked, which they are already. So now comes a challenge, which is, how do you do that? What are the processes? You know, when an attorney goes to law school, he's not learning what the law is. He's learning what the procedures are to run things through court. And they tell them that when you get out and you start practicing, when you get to a law issue, you go look it up, and you'll find out what the law is at that time. Because the procedures is what's important. How you do it, when to do it, what way to do it, etc. And only if you can't win on procedures do you go to law. Because if you can win on procedures, you don't need any law on your side, right? You got them procedurally. Because procedures is first, the law is second, and if you can't do that, then just slander them. but you know, make the jury think they're no good people, so they'll, you know, go against them. So, as I think as they used to say, if you if you have the law on your side, in other words, if your case is in agreement with the law, then talk the law, and if your case is if you don't have the law on your side, then go with procedure, and if the procedure and the law aren't your side, then just slander them, tell the jury what no good people they are, so that you can win that way. But the first step is, of course, administrative. Now, when you send letters administratively, as I was talking about before we started going here, that many times, you know, I've had this happen to me, that when I sat down and talked with an attorney, he would tell me, or had told me, this one instance in particular, he says, I know this wasn't written by an attorney. And I said, well, how do you know that? And he says, by the case site. He says, you left off the year. He says, and I know, therefore, that you're not an attorney. And I said, well, I'm not an attorney, not that I have to be one. And he couldn't address our answers anyway. He couldn't address the issues that we're doing, so he worked on slander, you know. He didn't have law and he didn't have procedure, so he resorted to slander, telling us what no good people we were. But that's all right, because we recognize what no good person he was too, so we're all in agreement. But when you write your letters, if you want to make your letters appear that they were done by somebody, assuming that your reasoning is logical and you have the proper cites behind you, if you want your letter to look like to the attorney who is most likely to read this, then you need to make your cites proper, that which they will look at and say, oh yeah, this is all done proper. It can't be done by somebody who doesn't know what they're doing. So how do you do that? Well, the things that are most cited, at least in cases or letters that we do, are either case cites or statute cites, cites of the law. The way you're supposed to do those cites is this way. And by the way, you can get all this information in this nice little thin book called the Blue Book. You can see it's not that thin. You wouldn't think there'd be so many ways to reference something, would you? But, pardon? It's called the Blue Book. Okay. Okay, the Blue Book, A Uniform System of Citation. This is the 16th edition. And all of this book is summarized on these 2 pages. Isn't that great? Great what they can do with 2 pages. You can get this book usually in a law library or not a law library, but a law bookstore. You'll find a lot of law bookstores on campuses, especially any campus that has a legal department for training people how to be lawyers. And because this is a standard thing, the Blue Book, and all law students have to have something like this so they know how to do their cites. Because they're said, you know, they don't waste their time teaching them how to do a cite. They may have a short course on that, but it's here in the Blue Book. So you can learn how to properly do it. Yeah, they do test them on it. So now, let's say that you're doing a case. Here's the nice thing about the back page, is that here it tells you if you're doing cases, like here, these are how to do your cases. And there's how to do your legislative matters. Here's how to do books, how to cite your books. Here's how to, this is journals, which is not that important, but it's got all these various things that you can cite. Now, your legislative matter would be your case, would be your statutes that you would be citing. And then, of course, obviously your case cites would be the cases that you're citing. When you do a case cite, first of all, the first case cite, everything's spelled out. That means here they show you Jackson versus, who is it? Metropolitan Edison Company, okay? Jackson v. period, because I've seen a lot of different things and a lot of different quote-unquote patriot stuff, and sometimes they have a capital V, sometimes there's a small v, sometimes with a period after it, sometimes they don't, and sometimes they underline it, sometimes they italicize it. And the reality is if you're going to do it, you can either underline it or italicize it. Either one's okay. The best method, because it's most commonly used, is to underline the entire case caption. So here it's Johnson v. period, Metropolitan Edison Company period. Okay, that whole thing should be underlined. That tells them that that's the case they're doing. And then you give them the cite. In this particular case, this is out of Fed Supplement. It's 348 F period SUPP period. That's where they pulled it from. That's for Federal Supplement. That's what that means. And then it has a number here, a 954. Well, 954, when you're looking at the Fed Supplement, that's the very first page of this case. Then it has a comma, and it has a 956-58. Well, that means that what they're referring to here, even though the case starts on 954, the actual information that you're referring to starts on 956 and goes through 958. So you don't have to put at or page or anything else like that on there. What you put is the volume number, the Federal Supplement, the page where the case starts at, comma, and then the pages you're actually quoting. If there's more than one, you put the dash. And then you would put in parenthesis the court that made the decision. So if it's the Ninth Circuit, if it's federal court, whichever district it is, et cetera, you would put, or the U.S. Supreme Court, et cetera, you put there the ones who made the decision there, and then you put the case year, the year of decision in that as well. Now, if there's other information, like it didn't stop there, whoever was the loser said, I'm not going to accept this, I'm going up. They appealed it. Then you'll have things like affirmed, which you have to what's called shepherdize the case. There's a set of books called shepherds. That's why they call it shepherdize. And shepherds, you can look up these cases by this number, this 348 Fed Sup 954. You can look up this case, and it will have a listing of all the cases. And the Shepherds is a fantastic book because you can look up all the cases that refers to this particular case. So if you have something in here and you like what it says, you look up Shepherds, and Shepherds going to tell you all the other cases where they also referred to this case and said, yeah, this is right. Or they're going to have the cases that says, no, this is wrong. So you'll know what the opponent's going to be bringing up. Okay, and they also have affirms. They also have information that says this case has been replaced or changed, or this case was in disagreement with what they said here. So you go through that and you find out everything that transpired from the time this case was decided until now. And by doing that, you know whether this is still solid case decision or whether it's been called into question or not. Because if it's been called into question, you can bet that the other side that has any kind of decent attorneys are going to bring that out. The fact that this has been decided by such and such a case, as this was wrong decision or it's in question, et cetera, and now the basis of what you were saying is, down the tube. You no longer have solid case behind it. Yes?
I have a question. Do all three branches, civil, equity, and criminal law, do they all run on the principle stare decisis?
Okay, you're asking whether, well, there's two primary.
Okay, stand by what has been decided.
Well, stare decisis applies just about anywhere. Once they've decided something, stare decisis means once decided, always decided, okay? And that's why we have all this case cite stuff, because what we're saying is this case has been decided, and therefore we don't need to decide it again, okay? And the idea, at least the idea at the time, was that once it's been decided, why have to go through this whole process of deciding what the answer is again when it's already been decided? Therefore, that'll shorten down our cases to something a little more manageable because we don't have to decide that issue again. It's already been done. The problem is that the courts have held that the only time that prior case decision really holds absolutely true is if your case is identical to the one that's being decided. Now, what's the chance your case is identical to the one that had been decided before? Almost non-existent. So guess what our stare decisis does for us? It makes our cases horrendously long as we go through and research and look for everything that looks kind of like it's what we're talking about, and they said something about that, and we bring it in as, okay, here's supporting information. They decided, even though the facts aren't quite the same, but you know, it's good enough to be say that we don't need to decide this again because he decided. They bring in another case where he says, well, you know, that's not quite the same, but you know, he said this over here, and it shows that they're not entitled to that kind of decision. And then the judge gets up there and he gets all these cases, and he's supposed to be up there neutral, right? He is a blank sheet. You laugh. Oh, so you haven't found the judge to be a blank sheet, have you? Well, we know that the judge is not a blank sheet, but that's what he's supposed to be. And he, as this quote-unquote blank sheet, takes this information from one side and takes this information from the other side and then evaluates it and makes a determination. Now, what the jury is supposed to do, they're the finder of facts, quote-unquote. That's not really what they are for. But what the court says and tells the people they're for is they're the fact finder. They're the fact decider. If there's facts in dispute, yes, you did this, no, I didn't, okay, that's a fact issue, okay, whether you did it or didn't. And so that's what the trial in front of a jury is all about, is to determine whether indeed that he did do it or he didn't do that, okay? But in our history, the history of this country, the jury was there to prevent the government from doing what they're doing now. Because the jury was not only the decider of facts, they were the decider of law. In other words, the judge was there to advise the jury of what the law was, but the ultimate decision on whether there was a violation of law or not was up to the jury, and it still is today. But the jury don't know it. But here's what happens. See, and here's why that was true, by the way. Just a little sidebar. The reason that was true is because, let's say you voted some people in the office and they passed some legislation and you didn't like it. For instance, they tell us that we live in a democracy, right? Now, of course, every time I read the Constitution, they talk about this republic. I guess all the people in the news went to government schools too, and they thought they live in a democracy. Okay, our founding fathers said a democracy was the most abusive form of government in existence. Now, why is that? The reason is because the democracy is mob rule. That is, the majority wins, right? Let's see. We've got more women here. No, we got less women here than we have men. Okay? Let's hold a democratic meeting and put this up to a vote. Okay? Let's vote and decide whether all the women should do all the work, do all the housework, take care of the kids and everything else, and we get to go out and golf and play and fish. All the men get to do that, okay? Let's vote. Oh, hey. Okay. Democracy. We get to go out and have a good time. That's democracy, okay? That's mob rule. Now, hold on a sec. Republic form of government. Same situation, okay? We say we want to have this thing. We voted in. We say yes. We put it on the books, right? Now it comes to the court, because one of the women didn't do what this law said she was supposed to do. Go out and take care of the kids, earn all the money, etc., while we went out and played. And so she's being prosecuted. Now the jury is made up of men and women. Let's say it's made up of 11 men and 1 woman. And she's being prosecuted criminally because she violated the law. In a Republican form of government, all you have to have is one person on that jury who says, I don't like that law, so I don't care if they violated that law or not because I disagree with it. And how many people does it take to get a criminal prosecution? In other words, a guilty verdict. It takes 12. Today. Well, hopefully it continues that way. But it takes 12, okay? So in other words, in a Republican form of government, all you need is a minority in disagreement, and that stops the government from enforcing, or the majority, from enforcing abusive laws on the minority. Okay? That's why our founding fathers set up a Republican form of government, not a democracy. Because in democracy, the minority is oppressed, always. Yeah.
You know why, what the media calls it now?
What, our government? What they call it now?
Democratic Republic.
Oh, okay, well, the media's got a new word, a democratic republic. That's like saying, giant shrimp. It's an oxymoron. You can't have a giant shrimp. Giant's big. There's a place over here called killer shrimp, and I consider that an oxymoron, That's a little killer. Yeah, well, they, word twisting is their favorite thing, yes.
Yeah, you're talking about jury nullification. That's exactly what you're talking about.
Well, that's a term that's been applied to it, but in effect it's what we were called to do. And they've titled it jury nullification, but the reality is the jury is the final authority on the law. And because people don't know that, when they get on the jury, they don't realize that their job is not only to judge the facts, but also to judge the law whether they agree with it. And when I hear on the TV these people coming out and saying, well, I would have voted for it, but the judge told me, blah, blah, blah. I say, well, what happened to your mind? What a great slave they are, The government must love them. Of course, they educated them, so they do. But they should have stood up for themselves. Where's their backbone saying, I don't agree with that. I'm not going to convict somebody on something I don't agree with. I don't care what the judge tells me. The judge is wrong, and that law is wrong, and I don't care what they say. I'm going to do what is right, no matter what they want. No, probably throw the whole thing out and have another jury, but you'll stop it. But
Yeah, I'm a juror right now. In the printed material and the judge's jury instructions both say that the judge is to determine all facts of law, and that what the judge says takes precedent over what we believe the law says or what the law actually says itself.
sure.
Like, in other words, whatever the judge says is law. That's what you have to.
Yeah, the judge is God up there. But you know what that used to be called? Jury tampering. Okay. And so they call it now that the judge has the decision, or what they say, the judge decides the law. That's what they call it. But it used to be called jury tampering because that's what it is. When you're trying to take away that which belongs to the jury, that right, and ascribe it to a single individual called the judge who has no right to assume that. But there's a lot of reasons for that, and I won't go into all the bankruptcies and all the other stuff that people talk about. And the martial law, and the dissolution of Congress from the American Civil War, and other things of this nature. But these are things which are fantastic studies, but for taking a case to court are irrelevant at this point. All right, so when we cite a case, going back to there, after you cite a case, if it's been taken up beyond that, it'll say whether it was affirmed or denied or reversed or whatever. And you would then put down that descriptive matter, what happened later, and you would underline that as well. Okay? And then you would give the case cite for where that affirmation or denial or reversal, etc., was heard. Then, in this case, they didn't like that, and so they went up to the third, it was affirmed in the Third Circuit. They didn't like that, so they went up to the Supreme Court, where the Supreme Court affirmed it. So you see they have an affirm here for the Third Circuit in 1973. They have an affirm here in the U.S. Supreme Court in 1974. Okay, and it gives the case cites for each one of those. That is 419 U.S. U period S period 345 parenthesis 1974. You don't have to put the court because U.S. is U.S. Supreme Court. So you don't have to put what court it was in there. Okay. Now, there's only one Supreme Court. Right? So you don't have to. The federal courts, the circuit courts, like there's 9 circuits. Okay, so you have to tell which circuit we're talking about, because even though, and this is really, if you want to know how screwy our legal system is, we'll deal with the IRS, okay? First, I want to explain there's 9 circuits, right? And so with 9 circuits, we're in the 9th Circuit here in California. With that, any decision of the circuit courts in the 9th Circuit is binding upon the lower courts in the 9th Circuit. However, in the courts in the other circuits, the 9th Circuit decisions are not binding upon them. Okay? It's It's not binding, but it's influential. It can influence their decision, but it's not binding upon them. Now, guess what the IRS do with that? Okay, fortunately, the Supreme Court is binding upon them all. It's the top. But guess what the IRS do that? You get over here in the Ninth Circuit, and they make a decision, which is fantastic for everybody here, and the IRS say, we're not going to acquiesce to that. We're not going to agree to it. So every person has to go fight this case individually up through court because they don't agree to it. Well, where is that in the law? That this government agency can say, I don't agree with it, so it don't apply to me. And the courts don't say, you got another thing coming here. We made this decision. It's binding. But the IRS do that, and they don't make them, face up to that. They don't make them acquiesce to it. They really, when they do make a decision, Ninth Circuit, then everybody in the Ninth Circuit actually doesn't have to find it. But all the other circuits, they'll either acquiesce or non-acquiesce to that decision. And if they non-acquiesce, that means in all the other circuits, you're going to have to fight it there as well, even though it's been won over here. Are they telling me that the federal law is different in the Ninth Circuit than it is in the Third Circuit? It's the same written material. If they make a decision, I think that it should be binding if it's federal, because it's supposed to be applied uniformly across the country, but it isn't. So, just so you know, this is the fun stuff about law. It's fun, right? Now, as a private citizen, you can non-acquiesce to whatever you want, but don't mean a thing. Okay? Yeah. Now, let's say, okay, so we know how to write the original citation. You spell out the whole proceeding name, okay? So in this case, it's Jackson versus Metropolitan Edison. You underline the whole thing. You give the full case cite, and then you cite where that was decided and what year, and then if it went on beyond that, you tell what happened to it, whether it was firm, denied, etc., and you give that cite as well in the year. Now, once you've cited something, if you cite it again, you don't need to spell out the whole thing. You can make an abbreviated version. And in the abbreviated version, what you do is, if it's got U.S. government or any kind of government in there, you don't use that name. You use the other one. Okay? So you take out the U.S. government, and usually in our stuff that we're talking about here, we're talking about U.S. government or California government, the state of California, etc. So you forget that one, and you use the other name in citing this stuff, and you don't have to do the full cite because of that. But you can get the blue book, and it'll tell you how to take care of that. But you can also fully cite it again if you wanted to. But generally with our stuff, you only cite the case once. You don't need to cite it twice because we know what we're doing. We don't have to repeat, and we don't forget, right? We're not in the practice of, lawyers are in the practice of law, and they keep practicing until they get it right. Well, hopefully, we are not in the practice of law. We can get it right the first time. So for all you lawyers out there, pardon me. Now, the legislative material, when we cite a case, generally what you will do is you'll cite the name of the case, and for instance, if you're to cite a reference out of the United States Code, okay, you wouldn't underline any of it because none of it is the name. It would be 28 USC, that stands for United States Code, U period, S period, C period, and then a section number, the section you're talking about, and then you would put in parentheses the year of the code you're citing, so 1994 or whatever, in parentheses, and then whatever you're talking about there. And that's how you'd cite most of the other cases, most of the legislative enactments or the USC titles and stuff like that. But if you get this book, actually the rules for how you cite your stuff is actually only right here in the beginning, just a little bit right here. Actually, that's a lot more than what you need. There's only about that much. And everything else is just how to make it different in various states. So it's not that hard. And if you cite everything right, then you'll look better to the people who are reading it, in particular to attorneys, and they won't be discarding your stuff thinking, oh, these people are non-attorneys. And unfortunately, attorneys have this arrogance about them. Because it is a boys' club. That judge up there is an attorney, okay? And they have this boys' club type mentality. Not every single one of them, but more than they should, over half. And that's more than they should, way more than they should. And because of that, we have to understand that the law says we're to be granted a greater leniency in dealing with our stuff. So now it comes to that term pro se, pro per, injured party, all the other stuff. When you go into the court, and this is, I think, most people don't understand what pro per, pro se means, okay? And I'll tell you something, you'll never forget what it means after I tell you this, okay? This is the definition. Pro se is someone there representing themselves. It's called proper self, okay? Pro per is someone there representing their person. In other words, they're there as the proper person. Now, on your wedding night, would you want to be there in person, or would you want somebody to be there pro se representing you? Okay. Pro se, somebody is representing you. Pro per, you are there yourself. Okay? So you should be able to remember that. And that's the difference. If you go in pro se, then what they're saying is you are somebody else representing the party, just like an attorney. And you're held to the standards of an attorney. So you never want to be pro se. Pro per is a person representing, or the proper party to the action. Okay? And that's why when the judge says, well, are you representing yourself? The answer is no. I'm not representing myself. I'm the proper party to this action. If you are the proper party. That's another thing altogether, joinder party and stuff. We won't get into that. But if you're there representing yourself, you're pro se. Okay? If you're there and you're proper person, you're not representing yourself, you're just there as the proper person, you are pro per. And so never be pro se, because then you're held to the standards of an attorney. And you don't want that, because attorneys can get sanctioned. You don't want to be sanctioned. What?
In fact, are you granted greater leniency for being in pro per, or is that
Yes.
upheld?
A person who is pro per by law is granted greater leniency. In fact, we just had a case, not me myself, but another gentleman who I know, and the judge, this is really funny, but the the judge gave them a chance to amend their return, and then they amended the return, brought it back, and the judge gave them a second chance to amend their return. And then the head of the law firm came in on this case. This had to do with banks and houses and stuff like this. And so he came in, and he was going to argue this case, because his little flunkies who he had doing this weren't doing a very good job. You know, this judge was letting them amend these cases left and right. There were complaints. And he was in there, and the judge said, okay, I'm going to let you amend. This is the plaintiff now. This is the third time for the plaintiff. The bank was the defendant. Says, okay, I want you to amend your complaint. And this guy went ballistic, the head of this law firm. Says, you can't do that, and da 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 da. And he says, sir, I'm giving them time to amend their complaint. What could he say? He walked out in a huff, and then in the hallway he told the guy, he says, if you don't do whatever, says, I'm going to move for sanctions against you. He just laughed at him, because he knew darn well he can't sanction him. He wasn't pro se. So, but it was really funny. The guy went ballistic. Head of the law firm, big prestigious law firm. And he lost it in court. Now, there's two types of cases. We're going to now go through how you take this case and how you take a case Okay, the first thing you have to do with a case is you have to write it up, okay, properly. There are certain types of actions in a case, and these are all spelled out. And if you go to the law library and you have a particular action, somebody did something to you, okay, you can look up the various types of actions in books called AMJUR. That stands for American Jurisprudence. They have the AMJUR law, and then they have the AMJUR pleading and practice forms. Now, the pleading and practice forms are great in that at the beginning of the pleading and practice for the particular action you want to do, they've listed all the elements you need to prove as the plaintiff or need to disprove as the defendant. Now, the burden is on the plaintiff to establish all the elements, because all the defendant has to do is disprove one of those elements that have to be established, and if he can do that, there's no action lies, okay? So the plaintiff has the burden to establish all these things. There might not be that many. There only may be 4 things that you have to prove, and some of them are pretty obvious, like did you own the property? Well, that's easy enough to prove. Did you pass the property? And I'm talking right now of something like conversion. With a conversion, that's you gave some property that you owned to somebody, and they didn't return it to you. So now we have a conversion action. They took it and converted it to somebody else's use. Theirs or somebody else's, okay? So you have to prove, number 1, you gave it to them. Number 1, you owned it, okay? Number 2, that you gave it to them. Number 3, that you asked for it back. And number 4, they didn't return it, okay? Those are the 4 things. And if you can establish those 4 things, you've got a shelf of conversion. And these things aren't hard to prove, but based upon your case, obviously. But that's some of the things that you need to do. Every action that's out there has certain elements that need to be proved, and that's what judge looks at. Most people, when they file their actions, don't cover all the elements. And therefore, the case is thrown out because it fails to state a claim upon which relief can be granted. If you don't cover all the elements, you haven't made a proper claim. If you haven't made a proper current claim, they can't give you any remedy. If you can't give any remedy, then you fail to state a claim upon which they can give any relief. Fail to state a claim upon which relief can be granted. And so it's thrown out. And they don't tell you why. They just say, you failed to state a claim. Out it goes. And you're sitting there, well, what happened? And they're saying, well, you should have gotten an attorney. Yeah, okay, thank you. But that's what they do. Okay, so what you need to do instead is to find out what these elements are, prove those elements, and your cases will not be thrown out for failure to state a claim. Okay? And you'll find that in AMJUR. Any law library, especially in the courthouse, will have those set of books, and many others for that matter. But also, another thing you can do, which would be very helpful, is you can hire an attorney to assist you, not represent you. And he can help you with procedural matters and stuff like this, or maybe find out what kind of action you actually have. And that's not a bad thing, because as long as he's not representing you, you're in control. But if he's representing you, you're out, because an attorney only represents incompetents and infants. Okay? So if you are not an infant, then you're an idiot. Okay? And if you hire an attorney, you're an idiot. Okay? That's what the law says. What can I tell you? Yeah, what is it? Okay, this book, which I encourage everybody to get, is called Represent Yourself in Court. If you can find it, good luck, because they've ran out of the set they have. They're printing a new set, but it hasn't come in. They say it's going to be the end of February.
Who's the author?
Who's the author? The author is Paul Bergman and Sarah J. Bergman Barrett. It's by Nolo Press. Okay?
When you say they're out, I mean, where do you find it?
Well, I found this at Bookstar, but you can get it just about anywhere when they have it in. The problem is having it in right now, because it seems like everybody went out and got a set, and now they don't have any.
Is that discussed the same like you're talking about with amateurs and?
Well, not directly. That's why I'm putting it in here. But they do tell you that you should get help from an attorney to assist you, and he would probably tell you or show you what the elements that you need to prove. After all, that's what you're paying him for, right? You want to be able to, and he might even write up some information for you, and there's nothing wrong with that. So you just don't want them to go in and lay it before the court. You want to do that, okay? And it's not hard to do because court, the overall, the macro view of what goes on in court is this. You file an action, okay? They file an answer to your action. And if you wish, you can then file a response to their answer, okay? Those are called pleadings. Now, there's also, if they think they got a claim against you, they could file a counterclaim against you. You could file an answer to their counterclaim, and they could file a response to your answer, okay? That is everything that they call pleadings in law, okay? Those are pleadings. Everything else, all the other paper you file, are motions. Because a motion is to move the court. For instance, let's say that I'm up here, and I'm the plaintiff, and the defendant's over there, and I file a motion with the court to have a Coke, or actually a glass of water, on the table to keep my mouth moist. Okay, I could file a motion requesting that they have that right there, and the court decides whether they're going to grant it or not. Generally, it's something like that they'd grant. So now the other kind of motion I could file, which is not so benign, is I could file a motion after he files his answer. I could check the facts that were pleaded and the answers that he put in and say, well, based upon his response, let's move for what's called a summary judgment. In other words, well, Judge, if you look at what the facts I presented, you look at the facts he presented, you can make a decision right now. We don't need the jury who's going to decide the facts, because the facts are in agreement that I should win, okay, based upon the pleadings in the case. That is your complaint and their answer to it. And so, but in California, you got to wait 60 days from the time that you filed and they answered before you can file for summary judgment. Okay, they have 30 days to answer from the time that you filed your case. So the way it works is you file your case, you file your complaint, your pleadings. They have 30 days to answer your pleadings, okay? From the date that they answer your pleadings, you have 60 days before you can put in a motion for summary judgment, okay? They have 60 days from the date you filed your pleading to put in their motion for summary judgment if they want one. So they get the first shot. The defense gets the first shot at summary judgment, and you get second shot. In between this time, they're going to have what's called a status conference. Now, the object of the status conference is to give the people a chance to decide this thing, settle it, which never happens. Because what the attorneys use the status conference for is to feel you out, to see what you know. And one of the things they ask you to do is to bring forward your evidence, to bring forward the witnesses that you're going to present, you know, the list of witnesses and the evidence that you're going to submit, and they have to bring forward their witnesses and the evidence they're going to present, and so everybody knows what the other person's going to be doing. So you can build your defense or build your offense, okay, your case. So, what's that? Well, there's lots of things that didn't used to be that are now. But then you end up going to court. Okay, so here, going back again, you file your complaint, file the answer, you can file a response to that. They can then file a cross complaint if they think there's really a damage against them, not the other way around. You can file an answer to that. They can file a response to that. That's pleadings. Then from everything on from there is called a motion. We then have a status conference somewhere in here. During this time, we also have discovery. That's where you put out either interrogatories, that's written requests for answers to questions, or you have depositions, that's physically having an individual there and orally questioning them with this court stenographer writing down the answers to questions, okay? That's the only difference between an interrogatory and a deposition is one is written and one is oral, okay? Then, and you can also have this thing called a subpoena ducis tecum, which is where you ask the person you're deposing to bring forward documents, okay? So a subpoena ducis tecum says bring forward the documents. And those are documents you're requesting. For instance, if you're in if you file a case because the bank took away all your money raided your account with improper documentation called a notice of levy, and you say, please bring forward the documents upon which you relied to take this money, okay? Bring forward all the documents that you relied upon to take this money, okay? And they bring forward this one little flimsy notice of levy. Well, now they've just answered the question. This is the only document. The significant thing about that is that if it's not for wages, if it's for retirement, the laws only allow them to take one check with that notice of levy. And what these retirement places do is they keep taking and taking and taking and taking. That's a violation of law. So when you ask for them to bring forward all their notices or everything that they relied upon, they bring forward one document that says if this thing was correct, they could have only taken one check anyway. And if they've taken it for a year, guess what you have? You have a very simple case to get back all that money and go after them for damages. Because I'm assuming you told them, hey, you can't do that. And they did anyway. So, anyway, that's for the sidebar. So we had the pleadings, we have the interrogatories, we have the depositions, we have the status conference, and then we get down to the next thing, which is going to be the jury selection. Okay, and the jury selection, they have usually about 18 jurists they bring in. They ask them questions. This is done in one of two ways. Either the judge asks all the questions, you get to give him some questions he can ask, and then he does all the answering, and he never asks it the way you phrase it, because the way you phrase it would dismiss most of them. So either he asks the question, or if he lets you do it, then both sides get to ask them a question, and after you go through your 12, you submit to the judge, or tell the judge, gee, I would I'd like you to release this one or that one, and they say, and the other side says the same thing. Then you bring in the next group, and you keep going until you fill it up, get all 12. Okay, so that's the jury selection. After the jury selection, then they have a very easy little process for carrying your case through. You have the plaintiff gets to say something, his opening statement. The defendant gets to say something, their opening statement, and then you start bringing on your witnesses and putting your evidence into the record. The plaintiff does it, the defendant does it. You bring on another witness, the plaintiff, and all the plaintiff does his, all the defendant does his. Then after that's all done, you then have your closing statement. And your closing statement, you get to say something, they get to say something, then you get to say something as the plaintiff. Yes?
Can you, I've heard that you can only introduce evidence that you present in your opening statement.
Actually, you can only introduce evidence that you showed that you're going to present during the status conference. But because they consider that unfair, right? Because you had hidden evidence they couldn't build their defense on, or as the defense, if the defense brought in something, it was unfair because then the plaintiff couldn't build his case because you had secret evidence, right? So he had no way to defend against the surprise.
In California.
Well, yeah, but it's not that way now.
California, the defendant didn't need to show his evidence to the plaintiff.
Yeah, well, being a criminal case is one thing. We're talking civil here, okay? So it's a different breed in civil. You don't even need a full jury to agree in a civil, So anyway, then after that, the judge gives it to the jury to decide the facts, because the only issue the jury, quote unquote, is going to decide, if they all believe what the judge is telling them, is they're going to decide what fact issues that you're talking about, whether those fact issues are more believable from you or whether they're more believable from the other party. They're going to decide those issues, and they're going to come back and they're going to be told what the elements are, what it is that they have to look for to decide this in the plaintiff's favor. And if they can't find that, then they decide it in the defendant's favor. And so they're going to be told what it is to look for. And you should already know what this is if you're the plaintiff, because you looked up an amateur and you saw all those things that you got to establish. So they're going to decide all these things. They're going to see if there's enough that weighs it in your favor, and all those elements are all proved in your favor. They believe you more than they believe the testimony and witnesses on the other side. Okay? And if they do, you win. If you don't, you don't. And if you don't, you just think there was a mistake in the way that it was handled. That's called a procedural error, and you appeal it. Okay? Because appeal only deals with procedure, not with facts. Okay? You can't appeal something that you don't agree with their decision, but they made no procedural error. They won't hear it. There's got to be a procedural error. For instance, procedural error might be that you showed, for instance, on this notice of levy, that the law says that there has to be a signature under penalty of perjury to make this thing valid, and the judge, and they don't bring forward any evidence to show to the contrary, and the judge says, well, because they have a valid levy, we're going to decide in his favor, right? Or the jury says, well, we're going to decide in his favor because he shouldn't be punished for just turning over money when he had no choice. Oh, wait a minute, you know, that's not right, because the issue is, was there a under penalty of perjury statement and signed under penalty of perjury on this document when a statute says it's required? And if they don't establish otherwise and they rule against you, then one of the key elements, or what they call an ultimate fact, hasn't been disproven. And it has to be disproven for them to decide in the other person's favor. That's a procedural error. And that you can appeal. And you ask the court, well, here's a record, here's a record. You can see they never disprove this element, and this element alone will establish that I shouldn't have any money taken because the document they used was faulty, period. And nothing else matters. Just this element shows that that should have been taken. And so that's a procedural error which you can appeal on. Now, okay, that's the overview of how it all works. Now we get into the elements of how it works. Okay, they tell you how a courtroom is laid out and about expert witnesses and stuff like that, which I won't touch on at this point. We talked about the complaint, on how you would do that. One of the things you have to do, by the way, is after you file your complaint, you have to let the other side know that you're suing them. It's kind of important, you know. They need to know they're being sued. So you do that by what's called issuing a summons. In other words, you take your complaint, you put a summons on it, and you have it served by a third party. A third party is anybody who doesn't have an interest in the case, which means it can't be served by you, can't be served by your family. It has to be done by somebody else. Somebody who's not a witness, somebody who's not going to be using your case for any other purpose, okay? So a summons then goes out, and after they get this, they have 30 days to reply. I'm dealing from the plaintiff's side because I'm presuming that we're going to use the court procedures to offensively, to go after them for what they have done, rather than defensively for protecting us from what they do. But, you know, it's all the same, whether if you're on the, if you're on the defense, then all you have to do is prove one of those elements aren't true of all the things they got to prove. That's all you have to do. You do that, you win. And that's the whole thing. So the thing that you have to do on the plaintiff is just the opposite on the defendant. Okay, you do the interrogatories, the discoveries, the requests for documents, and then you have what's called pre-trial hearings and motions. The pre-trial conference is a settlement conference. Okay, the settlement conference is where you're supposed to sit down and say, okay, let's hash this out. And you don't get too much of that. You don't get too much hashed out, anyway. Some of the pre-trial motions that you can put in. Let's say that, as what happened to a friend of mine on a OSC. An OSC is order to show cause. Okay, an order to show cause by the IRS, which usually issues this, is an order for you to produce your books and records, right? Please show the court why you shouldn't be ordered to show the books and records. Now, when you get the IRS's complaint, their complaint talks about how corporations are required to produce their books and records. Well, last I checked, most of you here aren't corporations, okay? And their whole case is based upon corporations being required to produce books and records. Because corporations have no civil rights. Only you do. Corporations do not. Therefore, they cannot refuse to produce those books and records. They are a creature of the state. And as a creature of the state, they belong to the state. And belonging to the state has the authority to request anything they possess. Okay? So if you have a corporation, understand you do not possess it. The state does. You are merely using it. It's state's property. Okay? So those people who have Nevada corporations, just remember, that still belongs to the state, and it's not yours. Even if they do keep your name off it, nobody knows who the heck owns it. It's still the state's property. Now, the other thing is that these pretrial motions that we're talking about is you can have what's called a motion in limine. Okay, what that means is they're going to limit your scope of discovery. That's how it's usually used. You're asking, you got this this notice of lien, for instance, and you're asking him, where he has his bank accounts and who he associates with and how many times he has sex with his wife and this kind of stuff. And they're saying, wait a minute. This is a notice of levy. This has nothing to do with that. That's all extraneous. And so they'll file a motion in limine, or the government may do the same thing with you, And so you'd file a motion in limine saying, well, we've got to limit the scope of his discovery because it's abusive, which that would be. Now, you also have a motion to strike. And this is what I was talking about. The guy had the OSC. A motion to strike is where they put in something that is irrelevant or improper testimony. Okay, for instance, in fact, what they say here, it's usually made after the judge has ruled that a particular testimony is not admissible. But in this particular case, this guy, this U.S. attorney, was calling this guy well, let me put it this way. They filed the OSC, he filed his answer, saying, hey, they're really trying to prosecute me criminally because he had CID agents escort us out of the building. They refused to give us a meeting. We had a books and records. We're willing to provide them, but they refused to give us the meeting and the hearing and allow our witnesses, et cetera, et cetera. So, and in addition, the IRS perjured his testimony because he says we refused and we got a stenographic record, which, by the way, I always bring with me, that says, and right here, that we said we're willing to comply with all the rules and regulations that you guys can think of, and we're here to cooperate. We're here to provide the records. Said I think about 6 times it was stated. We're here to cooperate. We're here to do this. And the IRS kept saying, well, we're not going to let you guys in here, and et cetera. And said, well, didn't we send you a letter? Didn't it say what our party composed of? Didn't we give you, 10 days to respond to this? Did you ever respond saying, no, you didn't agree with the party? Well, then you have no right to complain now. You can't complain after we get here saying, oh, no, we don't agree with your party. We give you plenty of time, plenty of notice to respond. You didn't do it. So anyway, so the agents put in the thing. He refused to cooperate. Perjury. So the answer related to that. Then the U.S. attorney responded to his answer with, this guy's an illegal tax protester. We weren't going after him criminally. This guy's violating the law. Well, wait a minute. Illegal tax protester, isn't that violation of the law? Isn't that criminal? He's violating the law. Isn't that criminal? We're not going after him criminally. Do we have a little problem here? We're not going after him criminally, but he's a criminal? No, I think we got a little problem here. And then the attorney was saying, says, we're not going to let him impose his view upon the rest of us. What's this got to do with anything? Imposing his view on him. Actually, he says, on the rest of us, like as though he's imposing his view of the world on him. In fact, that's what he said. His view of the world on me and the rest of us. And of course, so what's that got to do with this order to show cause, So that was frivolous. And he was talking and says, well, he was abusive and he was argumentative when he was there. Well, the attorney wasn't there. He can't testify to that. He has no say as whether he was what he was, because the attorney wasn't there. He's producing, quote-unquote, first-hand testimony, and he wasn't even there. So we put in a response and moved for sanctions against the attorney, because the attorney, number one, was violating his code of ethics. he was testifying to things that weren't true and that he has no firsthand knowledge of. And number three, he was slandering the defendant, and he was